My name is Mariam Haq, and I'm the legal director at Justice Project Pakistan. We're a small NGO based in Lahore, Pakistan, and we represent free of cost the most vulnerable Pakistani prisoners facing the harshest punishments, of whom uh, a set of people that we concentrate on are victims of torture. And in 2012, Justice Project Pakistan started their Pakistan Police Torture Project, which culminated in a three-part report on police torture based on reported cases of torture in a district in Pakistan. We looked at 1,867 cases of reported cases of police torture, of which we found that 76% of the reported cases, torture had been confirmed by government doctors who examined the victims of torture. In none of those cases were there any prosecutions. And this is ranging from the year 2006 until the year 2012. So it comes down to about one case per day. Um, we're here today in the aftermath of those reports because still nobody is being prosecuted, even though Pakistan is a signatory and has ratified the Convention Against Torture. Um, there are a couple of reasons that we came across in our research, which was based on the medical records of these victims of torture, as well as in-person interviews that JPP conducted along with the Lowenstein clinic at Yale. And what we found in these cases, which I'm sure Mr. Mendez is going to confirm as well, because this is an underlying issue that's been continuing since even before Pakistan ratified the Convention Against Torture, which is lack of accountability and complete impunity as far as the police is concerned. Um, what the reason why this is so is because we have no laws in Pakistan that actually criminalize torture and no laws in Pakistan that even define it. All we have is an article in our constitution, which is Article 14, which just says, without defining what torture is, that you cannot commit torture to extract evidence. Um, Without a lack of a definition and without the act actually being criminalized, there's obviously no prosecutions to that effect either of the perpetrators of torture. And in Pakistan, the biggest perpetrator of torture is the police. And the reason for that is because the police has been, over the years, always been used as a political tool by different political parties to exert pressure. And because they've been used as that force to make whatever they need to happen, they've also now developed this culture of impunity in themselves. And it's not only legally that torture is accepted, but also culturally that torture is accepted, which creates an even bigger problem to end or combat torture and provide redress to victims. Um, We've also seen that there is a complete lack of political will in Pakistan. I mean, we've come across cases where where there are young boys who've had, chilies inserted in their anus. We've had pregnant women kicked until they've miscarried. We've had boys picked up and not released until their parents paid $5,000 to get them released from the police who've been in, and they've been in legal detention for months. And these are cases that the government is aware of, and yet there has been no law that has been passed, and no judge or no um, person who has come from the state to say, okay, these people need to be prosecuted, these victims need redress. The victims are now so scared to even come forward because they're pressurized so much by the police, they're threatened further by the police, they're threatened by influential people within the community who side with the police. Um, and so we have an unwillingness to report it, as well as a lack of political will and accountability as far as combating torture in Pakistan is concerned. Um, Even though we've ratified the Convention Against Torture, we have not ratified we haven't even signed the optional protocol to the Convention Against Torture, and we've reserved, and we don't recognize the jurisdiction of the Committee Against Torture. So there's absolutely no room that we've left. By we, I mean the state of Pakistan has left for accountability on all fronts. We haven't even invited the Special Rapporteur on Torture since 1996, which is when he last came, and all the problems that he's identified still continue until today, the biggest of which, as I mentioned, is the lack of accountability. So that's why we're gathered here today, and um, we have Special Rapporteur on Torture, Mr. Juan Mendez, who is going to be able to help us understand why it is that Pakistan is particularly difficult in terms of combating torture, and what we can do to at least open our doors to the possibility that there can be accountability on an international front. How we can enforce Pakistan's international obligations because it has committed to following them. Then we have Justice Nasra Iqbal, who's sitting right next to me, who has been a very strong advocate of human rights in Pakistan. She's also been one of the first judges, senior judges at the High Court in Pakistan, which is an accomplishment very few women in Pakistan have been able to achieve. And she has also worked on she's also worked on a draft of the anti-torture bill, which has yet to be tabled, which she's going to be speaking about as well. And then we have Carla Firstman, who is from Redress, which is a UK-based organization that has dealt with that deals specifically with torture and providing redress and ensuring accountability, redress for the victims and ensuring accountability for the state and the perpetrators. And she will help us understand or advise us on how we can best make our state responsible for the torture that it commits on a daily basis, as our figures would tell us. I know that we're all short of time, so I'm going to try and keep within my time, and I'm going to move on to Mr. Juan Mendez and ask him to.
Thank you very much, Mariam. I want to thank the Justice Project Pakistan for this very good idea of holding a webinar, particularly in the wake of the very encouraging reports that JPP has produced, including reports on the specific perspective of particularly vulnerable people like women and juveniles or children. I was particularly impressed at the methodology of analyzing medical legal certificates by forensic doctors with a specialty on the matter of detecting torture, because I think that their contribution can be extensive to our common task of abolishing torture in our time. In fact, my next report to the General Assembly is about forensic specialists, forensic medicine, and their contributions to prevention and punishment of torture, and how we all need to enhance the ability of forensic doctors to participate in the struggle against torture. I think combating impunity for torture, providing victims of torture with effective remedy and reparations, and monitoring conditions of detention are all integral to the global effort to prevent and suppress torture and ill treatment. It requires involvement of various actors, including judges, prosecutors, lawyers, forensic experts, doctors, police officers, interrogators, detainees and former detainees, torture survivors, government officials, academics, and the media. The existing international legal framework provides a broad range of norms and standards with an ultimate aim to prevent acts of torture and ill treatment. The preventive obligations explicitly listed in the Convention Against Torture are the following: the prohibition of refoulement, Article 3, the prohibition of invoking evidence extracted by torture in any proceedings, or exclusionary rule in Article 15, the obligation to provide education and training to law enforcement and other personnel, the obligation systematically to review interrogation methods and conditions of detention, the obligation to investigate ex officio possible acts of torture, Article 12 of the Convention, as well as any torture allegations, Article 13, and obligations relating to the criminal prosecution of perpetrators of torture, that is, obligations relating to breaking the cycle of impunity for torture. But in addition, however, the umbrella clause in Article 2, Paragraph 1, requires state parties also to take other effective measures aimed at preventing torture. Such measures relate primarily to guarantees in the context of the right to personal liberty. For example, the prohibition of incommunicado detention and prolonged solitary confinement, right of detainees to have access to lawyers and doctors, obligations of states to maintain prison registers, etc., all of which are not explicitly stated in the convention, but that we read into the convention under this preventive obligation, the obligation to prevention. Their effective application, however, continues to be a challenge in most parts of the world. I am convinced that efforts to combat torture require a more victim-centered perspective that seeks an integrated long-term approach to adequate redress and reparation, including compensation and rehabilitation for victims of torture and their families, and their reintegration in society. But of course, the main right that victims have is the right to see justice done, the right to see the state investigate, prosecute, and punish every single act of torture that is committed. That is why this reports that Justice Project Pakistan has issued, with their heartbreaking personal testimony by victims, puts a light on the survivors and their testimonies at the center of our attention. I'd like to say a bit about the importance for Pakistan to sign and ratify the optional protocol to the Convention Against Torture. Pakistan, of course, has ratified the convention itself, but there are gaps between laws and implementation, and this is a key challenge. The existing international legal framework provides a broad range of norms and standards, in particular the preventive obligations that I have explicitly mentioned. First, it requires a focus on constitutional, legislative, and administrative reforms that need to be expedited to ensure the establishment of solid safeguards against torture and ill treatment. Secondly, these safeguards have to be realized, have to be put in practice on a daily basis, and that is the ultimate challenge and the key to prevention of torture. My mandate has on numerous occasions acknowledged the multifaceted dimensions of torture and ill treatment, and has emphasized the importance of approaching the prevention of torture from a multidisciplinary perspective. While suggesting that the optional protocol is the most effective and innovative method for the prevention of torture and ill treatment worldwide, my predecessors and I have emphasized the importance of various disciplines and different key actors working towards effective prevention. During the fact-finding missions, my mandate has reiterated that constitutional, legislative, and administrative reforms be expedited to ensure the establishment of solid safeguards. We have also identified lack of proper criminalization of torture, the absence of impartial investigations into allegations, and failure to prosecute perpetrators as contributing to the persistence of torture. Furthermore, we have provided an analysis of the three main obligations under the Convention and the optional protocol. The first one, fighting impunity; the second one, providing victims with reparations and rehabilitation; and the third, establishing effective national preventive mechanisms to inspect places of detention. The effective implementation of these obligations would, we assert, contribute to prevention of torture everywhere. While the appalling conditions of detention in most countries could be effectively addressed by implementing the body of principles for the protection of all persons under any form of detention or imprisonment, the Convention and the optional protocol contain a broad range of very specific state obligations aimed at preventing and combating torture. No further standard setting would be required, at least at the international level, but there is a pressing need to implement existing standards. And in the case of Pakistan, I would suggest a pressing need to sign and ratify the optional protocol and establish the national preventive mechanism contemplated in that optional protocol. But in addition, there are numerous methods of prevention that have been developed in the past, which, if adequately implemented by states, could help eradicate torture. And I mentioned them as a sort of a preliminary agenda for a national preventive mechanism for when Pakistan actually creates it after signing and ratifying OPCAT. First, the abolition of secret detention. Second, the abolition or tight regulation and control of incommunicado detention, because it may be necessary for a brief period to have somebody incommunicado, but it should be carefully and tightly regulated. The third is a proper registration of every detainee from the moment of arrest or apprehension. The prompt access to legal counsel from the moment of arrest, actually I would say from the moment of deprivation of liberty, however that is called in the domestic legislation. And that access not only to a lawyer but also to relatives of the person who is deprived of freedom. Next, the prompt access to an independent judge with powers to rule on the legality of the arrest and the conditions of detention. Next, the strict respect for the presumption of innocence. The prompt and independent medical examination of all persons deprived of liberty immediately upon their deprivation of liberty. Also the video or audio recording of all interrogations. The prompt, impartial, and effective investigation of all allegations or suspicions of torture. The inadmissibility of any evidence obtained under torture or that has originated in torture, even if committed against somebody else, and the effective training of all officials involved in the custody, interrogation, and medical care of detainees. Now, this is only a sample list, of course, and I'm sure you, from your experience, you can come up with more specific mechanisms to prevent torture. As mentioned earlier, the regular inspection of places of detention remains a most effective preventive measure against torture and ill treatment. Under appropriate conditions, it can ensure excuse me, the adequate implementation of these safeguards that I've just mentioned. It can create a strong deterrent effect and provide a means to generate timely and adequate responses to allegations of torture and ill treatment by law enforcement officials. In this context, the ratification of the optional protocol and the creation of independent national bodies to carry out unannounced visits to all places of detention certainly would constitute an effective measure to prevent torture in the sense of Article 2, Paragraph 1 of the Convention. Regular and unannounced visits to places of detention is key practice to help prevent torture and ensure effective reporting mechanisms are in place to report allegations of torture or ill treatment. I would add, however, that it would be important for the national preventive mechanism to incorporate a strong, robust relationship with civil society organizations and to allow civil society organizations to participate in the daily or in the regular inspection of detention centers. States often experience lengthy delays to ratify or or to implement the OPCAT. The rapporteurship has noted this in some of the visits we have conducted. And we have experience on providing expertise to government to help ensure a speedy ratification process and to provide guidance on the practical steps towards implementation. And by the way, the Subcommittee on the Prevention of Torture, the implementation organ of the optional protocol, also has a practice of advising states prior to ratification and prior to implementation. If invited by the government, the subcommittee or the special rapporteurship can conduct a country visit and monitor places of detention and meet with detainees in private, whether or not OPCAT is ratified. An international monitoring mechanism cannot substitute for a national preventive mechanism to undertake regular and unannounced visits, but could be a first step to show how independent monitoring can be done and to share experience with national institutions that are trying to build up the capacity to undertake national monitoring and reporting. Of course, independent financial, budgetary, and other resources, including human resources, are essential to ensure transparency for monitoring of places of detention, not only for investigation of allegations, but also for prevention of torture and cruel, inhuman, and degrading treatment or punishment. In other words, signing and ratifying OPCAT and even implementing it in good faith will not solve the issue of lack of political will that Mariam has identified. But I think it could go a long way in building that political will that, in my experience at least, is almost never present unless civil society generates the power and the influence to have the authorities acquire the political will that they will always need if we can envision a world without torture in the near future. Again, I thank you very much for your invitation, and I'm looking forward to the discussion.
Thank you so much, Mr. Mendez, for your very, very helpful recommendations. I think one of the ones that I found most interesting was that the subcommittee, and I didn't know this earlier, can be invited and advise the state, even if the state is not a party to the optional protocol itself, and that's certainly something that we can look into to see if our government would be conducive to that idea. Um, I think your point about the having civil society being involved is also quite important, because if there is no pressure from the people who are suffering, then the government is not going to be taking note of that themselves. We're hoping build a pressure group with the consultations that we've been having on torture based on our follow-up reports on the abuse of women and the abuse of children by the police, to create that pressure group and take this one step forward and hopefully have our government convinced that they need to end torture in Pakistan. Um, I'm going to invite Justice Nasra Iqbal now to comment on what barriers there are that you've seen in your experience in Pakistan, and how the judiciary is actually dealing with the fact that there is an absence of laws where they can prosecute perpetrators of torture, and how they do react to when they hear. Because I mean, in the cases that we've seen, even when we report that our clients have been tortured, there is an examination, but there's no follow-up by the court, and there's disinterest. So
Thank you very much, Mariam, and it was very enlightening to listen to Mr. Mendez and whatever recommendations he had given. And I feel at least confident in the regard that Pakistan is a signatory to the UN Convention Against Torture. And not only we have signed it, we have ratified it, and we have held multifarious seminars in different fora all over Pakistan, where not only NGOs but the police officials and government officials awareness has been increased about what comprises torture and how we can avoid it. And we have been busy. We ratified the convention in 2010, and ever since then we have been trying to formulate a proper legislation against torture, and it was to be presented to Parliament last month. You know, sudden turn of events in Pakistan has brought about a situation where the parliament is discussing more the question of its own powers and its jurisdiction. And until we overcome that, we will not be in a position to table the bill. But I have met certain legislators, and they have all been very, very receptive to the fact that we must pass this bill as soon as possible. But even in the absence of a specific law against torture, I am happy to say that the Constitution which guarantees the fundamental rights to all citizens, has very strong uh, preventions against torture in Article 9 and 14 of the Constitution. And if they are properly implemented, we would go a long way in having torture and abuse of police power or public servants' power reduced to a minimum. But the fact of the matter is, as has been already mentioned, there's a lack of awareness, and also the police are aware that they are not in a position to torture anybody or use any means of inflicting pain which is not incidental to lawful sanctions, and naturally it is in most often than not incidental to lawful sanctions. And we have a very strong law, the Pakistan Penal Code, which says Mr. Mendez was recommending that we should see where places of detention are and how are people detained. No person can be detained for more than 24 hours without being produced before a magistrate, and the magistrate has to give his body remand to the police for matters of finding out about the questioning about the offence that he has purportedly committed or he is uh, sort of accused of committing. But even in that process, they cannot use any unlawful force to extract any statement or confession from him. And if such a confession is taken by the police under Article 161 of the Pakistan Penal Code, that cannot be treated as evidence. The only evidence that can be taken from an accused is when he is presented before a proper court, which in this case is a magistrate. The magistrate would, under 164 of the CRPC, record his statement, and before recording the statement would get a complete uh, verification, and for himself a satisfaction, or herself in the case of a female magistrate, that the person is making the statement voluntarily and without any coercion, and no police officer or any public official or any person who could be deemed to be influencing or in any way uh, overcoming the views or influence the mind of the person who is accused should be present at the time that the confession is made. And the accused is first of all reminded that this confession is voluntary, and he is not to consider anything that should be coercive, and he is not bound to make any self-incriminating statement. But unfortunately, the police has been committing atrocities, and for that, of course, we have, as you know, the provision of habeas corpus. Anybody can find out whether a person is in illegal detention, and what the police does is, in order to avoid liability, keep people in secret places, as Mr. Mendez mentioned, that these have to be checked, but we have to find out where they are. And in such cases, if anybody finds out that a person is in illegal confinement, anyone, related or not related, having any such information, can immediately move a court for getting that person released from illegal detention. And this right is available to any person in Pakistan to obtain the release of anyone that he knows is in illegal detention. Of course, we have a great problem here about violence against women, which is, I think, the greatest form of coercion or extraction of evidence from people for who may or may not have committed an offense. That the women folk are subjected to all kinds of illegal harassment, confinement, and also inflicting of pain. And as was mentioned by Mariam, that pregnant women are mistreated till the extent that they lose their pregnancy. Young children who are vulnerable to this kind of infliction of pain are subjected to all forms of torture which could eventually mar their whole personality, and it would affect their whole lives. But I think that civil society has now become very much more aware, and there has been a publicity about the fact that torture is not permissible uh, under any circumstances. And in this context, I would like to say that the home is the first place, and unfortunately, The Convention Against Torture does not specifically address this subject. And domestic violence is a problem which is endemic not only to Pakistan but all countries of the world. But in Pakistan, it is of, I think the volume is much larger. And we have 4 provinces, and out of the 4 provinces, 2 have passed the law on domestic violence, but 2 of them need to pass it, and that would be a great step forward towards, if there is less domestic violence and no infliction of pain on women and children in the domestic environment, it would help people become aware also of the fact of public domain that this is not to be done. Another problem we have had, which creates an impediment against fully implementing the Convention Against Torture, is that, as you know, we have been victims of terrorism for more than the past 12 years. And these terrorists, when they are at all captured anywhere alive, then they, it is considered to be appropriate not to keep them in a place where it is known. And that has been for us a great problem. I've been on the Commission of Missing Persons, where we try to find out where people are kept who have been taken away from their homes on the allegations that they are terrorists. And it was very difficult to be able to recover these persons from the custody of those who think they are performing their duty for the state of Pakistan, saving the majority of the population from acts of violence by these militants. And now, I think I was probably partly responsible, being a member of the commission. We had this law, which is the Pakistan Protection Act, which is a very controversial law, and human rights activists have said that this law uh, needs to be amended. Well, it's only been in place for 2 years, for one thing. And in those 2 years, we will find out how it is being implemented, but I still feel it's better than no law, where people were taken away and kept in confinement and their families never knew where they were. The commission could not find out where they were. Nobody had any access to them. And it was years. In some cases, we could not find out about people who had been taken away maybe 10 years ago, immediately after 9/11. The ones who were taken away recently, we managed to get them out, and I think modern technology has been very helpful. There are the CCTV cameras and other things which help. But coming back to the subject of courts, whenever we have found out that anybody has reported that a person is in illegal confinement, the judge of whichever court this is brought through that their notice would immediately send a bailiff to recover the person who is in illegal custody. And when recovered, if found there are marks of injury on the body of the person who has been illegally confined, to get the person medically examined. And if found that the injuries are such which would have been inflicted while he was in illegal custody, to take action against those who are responsible. And I think that the courts have not shied away from bringing charges against the police, and the courts do it themselves. But this is a more recent development, and I think the Supreme Court of Pakistan has been the pathfinder and has led this particular movement of getting people compensation. First of all, finding out who inflicted pain or injury on them while they were in illegal confinement, why they were in illegal confinement, recovering them, and then not only uh, putting penalties on the persons who were responsible, but also getting that compensation passed on to the victims, or in case there is a death in custody, which also is not as often as we are led to believe. As you know, in Pakistan, there is a complete moratorium on the death penalty. We haven't had the death penalty being implemented for the past 6 or 7 years now. And I do believe that there's no likelihood of this being recommenced. There are people on death row, and they are another set of people who I think we have to relieve from torture, and probably the World Justice Project, whom I commend for whatever they have been doing, have been looking into this matter and have been going to prisons like probably Abu Ghraib also, and gone, or in Afghanistan at least. And well, we are close neighbors to Afghanistan, and whatever happens there has its effect, like a domino effect, on Pakistan too. So I think it's very important that they have been able to have access to these people who are victims of torture in Afghanistan, or they've been illegally confined, to bring them back, if possible, rehabilitate them. So this is also a major concern, that the people who have been victims of torture should be rehabilitated, because it's a very traumatic experience. And I'm very glad that there are now various NGOs who are undertaking this, and the courts, particularly the Supreme Court Human Rights Cell. There are several reported cases of people being recovered from the confinement of public officials, and of the police being given proper medical treatment, being the perpetrators being penalized, and compensation being given to those victims who have been also, the process of rehabilitation has been advanced. So I do feel, I'm confident that as soon as things settle down also on the political and the scenario in Pakistan, this bill will be tabled. And the kind of receptiveness we have in the public representatives, I think is a very good start.
Thank you, Justice Nasra. You gave us a very complete picture of what the scenario looks like from a judicial point of view, and what the obstacles are and what the barriers are. So even in cases where the law does exist, there are shortcomings, because as we can see, torture is still quite rampant and endemic in Pakistan. Um, Carla, we'd like to hear from you on that, because I think that your expertise lies in giving us recommendations for mechanisms that could translate the law into actual redress for victims, and prevention of torture. And we'd love to hear from you on the kind of mechanisms that you've used in the past and that may be useful for us in Pakistan.
Thank you very much, and it's a great pleasure to be part of this initiative. I think it's a great initiative, and I hope it leads to very concrete results. Before I turn to answering your question, or perhaps raising issues in relation to your question, I just wanted to note one additional thing in relation to Pakistan's ratification of the Convention Against Torture. 1 year after it ratified in 2010, it was due to submit its first report explaining how it complied with the provisions of the convention. That report was due in 2011, and so far the government has not yet submitted that report. And it would be really quite important to encourage the government to engage with the Committee Against Torture on this report, because that is a really good opportunity both for the government as well as civil society to think creatively and strategically about where the problems lie and how best to fix them. So 3 years overdue today. Let's hope we can see the report submitted before it becomes 4 years overdue. That's just a suggestion. In relation to the three issues, or the different issues in terms of what should happen at the domestic level, I think we need to look at it from a macro perspective. The practice of torture has to do with the unchecked power of the state and its officials, and the extreme vulnerability and lack of voice of the victims. The practice of torture perpetuates these very different polar opposites, and the mechanisms that one would need to put in place need to deal with those two very different polar opposites. So on the one hand, with respect to the states, we need to look at the range of different measures to increase transparency and accountability of governments. On the side of the victims, we need to look at the different kinds of vulnerability to torture, and we also need to look at how we can increase the voice and the agency of victims of torture to redress this power imbalance. That's one way in which to see from the macro perspective how big the job is. The Convention Against Torture thinks or refers to three main areas of obligations. So maybe I'll focus in on each of those. The first one is prevention. And here, what we've found has been most helpful in encouraging governments to actively prevent torture, firstly, is education, explaining to them that the obligation is not simply to avoid torture or to make sure that torture is in the criminal code, but to take active measures to ensure that torture is not possible. It's not possible to take place unaccounted for. Here it's quite important to note that states have a due diligence obligation to ensure that torture doesn't take place, and that the obligation to prevent extends to the private sphere. So even though torture is something that traditionally is an act which is done by a public official, when the state and the public official stands back and doesn't do anything to prevent serious harm perpetrated by individuals in the private sphere, accountability under the Convention Against Torture can follow. So training on that aspect, as well as the general aspects of how to prevent torture, how to conduct policing, how to conduct investigations in a way in which torture is not commonplace, is an important component of that. A second component on the prevention side is oversight mechanisms. What does one mean by oversight mechanisms? There are a variety of different models. In some countries there are police oversight mechanisms which deal specifically with the institutional structure of the police. Typically they are run by people who have some former affiliation with the police, who understand the chain of command, but are somehow independent. And they typically report to Parliament. Those types of mechanisms are really important to deal with the problem that one often has, which is that there is a closing of the ranks within the structure of the police. One can imagine if a victim applies or raises an allegation of torture to a police station, the other officials in the police station, maybe they saw the torture, but because they have the sense of solidarity with their fellow policemen, it's unlikely that the evidence in relation to what happened will come out. So finding some kind of an oversight structure is really quite important to try to break through this power dynamic within the institutional culture. The second aspect is prohibition. Clearly, and it's great to know that that there's some progress in this area, but the need to criminalize torture in line with the most progressive definition of torture that is. The Convention Against Torture has a wide definition, but one needs to take into account the specific context of Pakistan and make sure that the definition is as encompassing as it needs to be, given the situation that you are faced with. With respect to criminalization, the way in which we have seen progress in the area of prosecutions, the main blockage tends to be on the ability for victims to file complaints in full security. So this has to do with the woman who is raped in detention and has to go in to the police station and report her rape to a group of snickering male police officers who are not even having a pad of paper to take down what she said. How do we get around that kind of problem? How do we get around the problem of the person who remains in detention but is not given access to a complaints mechanism? So finding a structure and really pressing for the state to allow for an independent complaint structure within the police system and within this, I would say the same would apply to military or other kinds of structures, to allow victims to complain in full transparency is really important. In some countries, the complaint structure has been tied to a monitoring structure where the complaints body reports on the number of complaints it receives in any given year, which then Parliament can assess against follow-up. That might be one structure to move towards to increase transparency in the follow-up of complaints. Another important aspect on the complaint side is victim and witness protection legislation and procedures. If victims are forced to complain to the police officers who arguably are responsible in one way or another for their torture, without any independent obligation to ensure their safety, and without any legislation which prohibits reprisals against witnesses. I'm not sure what the legal structure is currently in Pakistan on reprisals, but that is a serious problem. Many countries have adopted victim and witness protection legislation. What is most important in the torture sphere is that the legislation caters not only for the situation of the key witness in a huge criminal prosecution, but the vulnerable victim who's raising a case against the state, which may require a completely different structure of protection than the mafia case or the organized crime case, where there's an insider who wants to testify and is at risk from his or her own gang, criminal organization. So the human rights case requires a very specific kind of thinking about how best witnesses can be protected. The third area, and well, finally, in relation to prosecutions, one would also need to consider that in addition to any criminal investigation and prosecution, what happens to those police officers or other officials who have been accused pending their criminal trial? Are they able to serve in the police whilst their trial is going on? Is there a system of suspensions? Given how long trials can take, and given the various impacts that can happen between when a case starts to when it ends, one should also think about complementary measures to ensure that the individuals who are accused are not in a position of power vis-a-vis the victim whilst the trial is proceeding. The third aspect has to do with reparation. Here we can think about two different areas. One has to do with compensation. Often the victims of torture will suffer both physical and psychological long-term consequences, which will significantly impact not only their own lives and well-being, but also the lives of their family. And these can have real economic impacts. So compensation is not simply a luxury in the context. It's a real need when it comes to victims of torture. The second aspect is rehabilitation. many of the torture survivors that I have worked with have lifelong psychological impacts as a result of the torture, which can impact their day-to-day life over the entirety of their lives. Rehabilitation is a necessary component of any full anti-torture policy. But also when we think about repair, we not only want to think about the repair of the individual who's been tortured, but one should also think about the broader aspects of reparation needed for the society. So what kind of mechanisms need to be put in place within the community where the torture has taken place to ensure that what happened is not able to happen again? What measures of non-recurrence are possible? Part of this may have to do with transparency, making it clear what did indeed happen, making it clear that this targeted, vulnerable group of persons who have been the predominant group of people who've been the victim of torture, that they're not the ones in the wrong. Sometimes it's about rebalancing the power to ensure that the state acknowledges and fully accounts for the fact that what it did was wrong to an individual or to groups of individuals who suffered in a particular kind of way. So maybe I stop there, and happy to pick up these points in the discussion.
Thank you so much, Carla. Those are all extremely helpful ways that we can think about providing redress to victims, especially in understanding that it's not just about giving them compensation, it's not just about having the perpetrator prosecuted, but it's also about making sure that the psychological effects of their torture are dealt with in rehabilitation, because often that's something that's ignored, particularly in Pakistan, because if you can't physically see the result of something, it's proved difficult to explain that those are injuries as well that need to be addressed, because they can have much longer term effects than physical injuries. We seem to be running a bit short on time now, because we did just have an hour, but we are receiving some questions from the people who logged in to watch, and I think this one is for you, Mr. Mendez, and it says, how can the government get away with no report in 3 years, and what can be done to ensure that this doesn't continue and to pressurize the government to submit a report?
Well, I think the committee itself maintains an ongoing dialogue with all signatories and reminds them of their procedural obligations to report. But unfortunately, that's not enough. It's very important to bring that up in more general fora where the government sits with its peers and can be singled out as not fulfilling its obligations, and that sometimes is a little more effective. But I think ultimately this is another aspect of where political will needs to be shown, and political will to sign and ratify is one thing. Political will to take seriously the obligations that arise out of signing and ratifying is always a different matter, unfortunately. And I think that political will, just like I said before, is really built by pressure from below, from civil society, from victims' organizations, from interested men and women who tell their government, you know, we want you to represent us in the international bodies in a serious way. And it is embarrassing for us to know that we are 3 years overdue. So we want the opportunity to go and discuss with you in Geneva what you have or have not done to implement the Convention Against Torture, and we need you to open that space by reporting on a timely fashion from now on, to report for the first time now and then on a timely fashion every 4 years thereafter.
Thank you. Carla, I think the next question is for you. It says that in a situation where you do have a compensation claim against the perpetrator, is it that the specific officer that should bear the burden of that compensation or the police department at large? And this is, it's actually an interesting question because this is something I think that the government actually believes is that the individual should pay the fine and they immediately pass on the responsibility of that torture to that individual rather than accepting it as a fault of the system.
And the law is not absolutely clear on this internationally, other than to say that it should not be, the victim shouldn't lose out because the individual perpetrator is without funds. There's the UN Basic Principles on the Right to Reparation, which specifically says that if an individual debtor is without funds, the state has the obligation to pay. So that's one on one side. That if a case is brought against an individual perpetrator, a civil claim, and that perpetrator cannot pay, then the state should pay in its place. The second point is that the state is responsible by virtue of the fact that this is a state function. Torture took place in the context of state responsibility. So there's two layers of responsibility. The individual's layer, which the state should take over if the individual is unable to pay, but there's a second layer, which is the responsibility of the state itself as the state, which always should come by virtue of the state.
Okay. We have one more, which I think everybody can comment on. And that one is, what measures should be taken by the government to protect women and juveniles in particular from torture during detention? So we're looking for specific recommendations or preventative measures to protect women and children.
Well, Pakistani law is very clear about the fact that children are not to be kept confined in same spaces where adult accused or under trial prisoners are kept. In fact, they are supposed to be kept in special places where only children are to be kept. And in that case, they are not to be subjected to any harm of any kind or even mental pressure for that matter. That's what the Juvenile Justice System Ordinance of Pakistan says. And now there is another special juvenile legislation which is in the process of being prepared and tabled, and I hope that will be even more effective. And for women, the same. They are not to be confined where there are other criminals and where there are women who are convicted. The accused are to be kept separately from them. They are to be treated in a manner in which women's dignity is not hurt. That I think is very important. And the question that Carla had raised, I think, about witness protection, the contemplated law which has been drafted is very clear on that witnesses are to be protected and also victims. And the victim has an absolute right to complain about what happened to him or her. And if for some reason she cannot complain, the minute she is produced before the appropriate forum, it is the responsibility of the forum under the law to take notice of the condition of the person who has been victim of torture and to itself uh, find out and investigate, send to the police, and then take up further action on it. And about the matter of compensation, of course, if the person who has perpetrated the torture is not in a position to pay, the state is liable because vicarious liability of master and servant, because it is the person who is in the service of the state, and there is no escaping punishment for a public official under section 197. That protection which CRPC would give to public officials is not available in the case of the perpetration of torture under this Anti-Torture Act.
Professor Mendez, would you like to comment?
Not really. Beyond has been said, I would say that not only my rapporteurship, but there are also other special procedures on the rights of women that have also issued extensive recommendations on specifics about how to protect women victims, especially when they file claims or complaints for their mistreatment. And in my not only in my country reports, but also on the individual cases, I urge states to adopt those kinds of measures. But I'm sure the other speakers have more experience with this than I do.
Carla, would you?
Maybe just briefly to comment that recently Redress was involved in a case of a woman who was in detention and she was forced to give birth with her ankles shackled. I think what I would say about that particular case and about the problem of women in detention is that it's not enough to be gender blind when it comes to women in detention. One needs to really look at the particularities of their needs and to make sure that they're dealt with. Sometimes excuses are given that, well, we don't have any female guards, so the women's private areas are going to have to be guarded by men. I would say that to throw that back on the government, there are certain obligations to ensure that women's privacy is respected, and we need to use that as a starting point, and that's where we have to begin with this.
Thank you so much. I think we've actually run out of time, and I know that everybody has a really busy schedule. But thank you so much for all of you for being here. I know that it's an exceptionally inconvenient time, especially for you, Professor Mendez, because it's now 9 p.m. But thank you so much. And I hope that people who tuned in managed to learn quite a bit, because we did.
One word of reassurance I would like to extend to the other two participants. The draft report is ready from Pakistan and it has been sent to the relevant authority. As soon as the chaos surrounding us settles down, I hope the report will be submitted to the appropriate
Wonderful.
Well, thank you very much again, and I really appreciate the opportunity, and I hope to have a similar discussion in Pakistan one of these days.
Yes, we're keeping our fingers crossed.
Thank you.
Thank you. Bye.
Bye.